So hi, everyone. It's Denise Wilson from PayerWatch and the Association for Healthcare Denial and Appeal Management. And I want to welcome everyone to our webinar today on Medicare Advantage denials and abuses, a provider call to arms. And we're very excited to have our special guest speaker today, Dr. Eddie Hugh from UNC Health. We have Kendall Smith, Bill Haynes, and myself. We were on a similar webinar on January 18th where we had Dr. Brian Moore from Atrium Health who spoke about this proposed rule that CMS has out about Medicare Advantage plans. And so I'm going to go over that a little bit at the beginning here just to kind of bring us all up to date and make sure that we're all understand what we're talking about today. The webinar we did January 18th, you can find that on the PayerWatch.com. The recording's on the PayerWatch.com website. You can go back and watch that. Today's webinar is being recorded as well, and we will have that on our PayerWatch.com website, typically within a couple of days. We're calling this, you may have seen in some of the material we sent out, we're calling this part 2 because last August we did what we're calling kind of part 1, which was talking about the request for information that CMS sent out about Medicare Advantage plans and some wanting to hear some of our stories that we've had with Medicare Advantage. So that's the difference. We had just the one webinar last fall in August, and then 2 this month on the proposed rule, which is out now. So let's see, I think we just talked about all this. So I'm going to moderate the discussion today, and I'm going to go through with links and addresses in a letter format to help you participate in the comment period. So the comment period's up until February 13th. So we only have a couple of weeks left to get your comments in. Attached to this presentation, you should have a command window that opened up. I can't remember what it's called, but a window that allows you to go to the, I think it's called Handouts, the little Handouts tab on your control panel, and you can download a letter format. So it's kind of a template that we've created for you to help you in the comment period. You can also download today's slides from there as well. Okay, so our special speaker today, Dr. Eddie Hugh, is the System Director of Physician Advisor Services for UNC Health. He served 3 years as the President of the American College of Physician Advisors and served on the Board of Directors. He's a Medicare regulations expert and serves on the ACPA Government Affairs Committee. Dr. Hugh is a fellow with the American Board of Quality Assurance and Utilization Review Physicians. If you don't know Eddie, you've got to get to know him because I just love listening to him. He's just a wealth of knowledge. Dr. Kendall Smith is a senior fellow in hospital medicine. He acts as chief physician advisor for PayerWatch and Appeal Masters, a leading appeal educator and appeal services firm. He's been deeply involved in denial and appeals management throughout his hospital's career and has served as a physician leader in hospital revenue cycle management team and serving as a physician advisor for clinical resource management. He's an AHIMA ICD, PCN, PCS approved trainer and ambassador. Bill Haynes serves as the managing attorney and legal director of the clinical legal unit for PayerWatch. He's a member in good standing of the Maryland Bar and a member of the AVIM Association and American Health Law Association. So his experience is in healthcare law, including managed care contract analysis, payer-provider arbitrations, independent review process. So he personally manages a team of attorneys who do legal research, answer legal questions, and draft legal language for our appeal cases, independent reviews, and arbitrations. And then me, I'm Senior Vice President of PayerWatch and Appeal Masters and President of the Association for Healthcare Denial and Appeal Management. I've been in healthcare for well over 30 years. I've been in denial and appeal management for 17, 18 years now. I do a lot of speaking and educating on this topic. If anyone ever needs a speaker for your various associations or for your hospital or whatever, please let me know. I'm happy to put something together to speak at your organization on this topic. We also, Dr. Brian Moore, who was on our presentation, January 18th, has also joined us as well. So thanks for joining us, Dr. Moore. A couple of his name says Kendall Smith, but I think you all know that's Dr. Moore there. So a couple of disclaimers before we get started. The content of this presentation is for informational purposes only, not intended to convey or constitute legal advice. Your receipt or use of the information does not create an attorney-client relationship. It is not a substitute for obtaining legal advice from a qualified attorney. If you need legal advice, please speak to your own attorney. Dr. Hugh's comments are his own opinions expressed freely without compensation and do not necessarily reflect the positions of any affiliated organizations. And I'm sure I could say the same thing for Dr. Moore. A little bit about who we are. PayerWatch is the nation's leading provider of payer denial, audit, and appeal solutions. We have a software platform to help manage your revenue cycle, denials, and appeals. And we also have a consulting and services side where we provide appeal writing services for your organization. And then the Association for Healthcare Denial Appeal Management is the nation's only association dedicated to those of you who are working in denial appeal management. We're here to support you, provide support, guidance, resources, education, so that we can help level that playing field so that our patients and healthcare providers are successful in persuading medical insurers to make those proper payment decisions. And we were created through the generous support of PayerWatch. So let's get into our content. A little bit of background so we're all on the same page. Back in April of 2022, which is not even a year ago, an OIG report came out that the Medicare Advantage organizations used clinical criteria that were not contained in Medicare coverage rules. And I think the second one is was really interesting to read in the OIG report. They felt that CMS guidance was not sufficiently detailed enough to determine whether MAOs could deny authorization based on their own internal clinical criteria that go beyond Medicare coverage rules. And so in response to that, Medicare in August then sent out an RFI, a request for information. They were looking for information back from not only providers, but also patients. And I know a lot of patients also sent in their comments on their experiences. So they were looking for utilization management feedback on coverage and care, as well as some other feedback as well. I think there were like 12 or more sections of different, avenues of Medicare Advantage behavior that they were seeking information on or feedback on. Almost 4,000 comments were sent to CMS on that. I think that was just a tremendous response. You could still go to the website and look through those comments if you'd like to. They're still out there. The two sections that we're going to talk about today primarily are the utilization management recommendations from CMS, and also a little bit about prior authorization. There are other areas of this proposed rule that you may be interested in, especially when it comes to skilled nursing, rehab, and those types of things. For our purposes, we kind of narrowed the scope down to just utilization management and prior authorization. So December 27th, CMS issued their proposed rule that is proposed to go into effect for contract year 2024, so that'd be next year. And they are proposing to codify existing Part C and Part D sub-regulatory guidance. And I think, Bill, you're going to touch on that just a little bit today to kind of explain a little bit about what that means. If you go to the website, which I have a very long URL there for you to access this proposed rule on the Federal Register, or you can just put in your favorite search engine, CMS 4201-P, and find it. If you go there, and look for provision E, that's the one that we are talking about, and that's the utilization management and prior authorization. And as I said, comments are due to CMS by February 13th. After our guest speakers talk today, I'm going to walk you through how to submit your comments, and a little bit more about Provision E, or I'm going to talk right now a little bit about Provision E and what that means. So Provision E, there are 4 items in Provision E that CMS talks about in kind of their introduction in the Federal Register. So I just have those quoted here. This is word for word what it says in the Federal Register proposed rule. So they're going to, in the proposed rule, require MA plans to follow traditional Medicare coverage, their NCDs or LCDs or statutes and regulations when making medical necessity determinations. Now, they're already supposed to be covering NCDs and LCDs, but they're going to, like I said, codify it so it's not a sub-regulatory guidance, but it'll be, you know, an actual rule. They also are going to require plans to provide a public summary of evidence that they use when they develop any of their own internal coverage criteria that they use to make medical determinations. They're going to require that any approval granted through a prior auth process has to be valid for the duration of that course of treatment. And any member who transitions from traditional Medicare to an MA plan or to a different MA plan, there has to be a 90-day transition period. So that's kind of a win for our patients to have that bit of protection. And then they're also going to require MA organizations to establish a committee led by the medical director so that they can keep current of LCDs, NCDs, and other traditional Medicare coverage policies, which I would hope they were doing anyway. That's in the proposed rule as well. And then one last slide before I turn it over to Dr. Hugh. This, if you haven't kept up with the trends, I know you all have. This is from Kaiser Family Foundation, their latest report on Medicare Advantage enrollment. And you can see for 2022, we're up to about 48% of Medicare people who are eligible for Medicare benefits are selecting Medicare Advantage plans. So we're just about to 50% now. So, and, you know, predicted to continue to grow. So we really have to, as providers, get our arms around this and determine, you know, how best can we meet the needs of our patients, but still be, you know, in the business of providing medical care. Okay, so Dr. Hugh, I'm going to turn it over to you.
Yeah, thanks, Denise, and thanks to PayerWatch for having me as a guest on this webinar. It's a pleasure to be here, and I'm excited to share you know, some of the recent developments and hope that the participants of this webinar will consider submitting their own comments to CMS with your own experiences and ways that that you can suggest to CMS to help improve the Medicare Advantage program. What I wanted to start with here is that some of the interpretations that CMS has put forth in this 4201P proposed rule are not new. In fact, they're not even close to being new, because, you know, when you go back and look at some of the things that the OIG has said in the past, not only in the April 2022 report, but I think even in the prior report that they published on Medicare Advantage denials. And when you look at Maximus, which if you don't realize, Maximus is the independent review entity that is charged with Medicare Advantage oversight. When you look at the oversight of Medicare Advantage plans, there is a 5-step CMS appeals process that is available to beneficiaries should beneficiaries choose to question a denial that's issued by the Medicare Advantage plan. Level 1 review is with the plan itself. And then if the plan upholds the denial or does anything other than issue a fully favorable determination to that appeal, they actually have to auto forward that appeal to level 2, which is the independent review entity, which is Maximus. So Maximus actually holds the federal contract for this very important place of Medicare Advantage oversight. We got a glimpse into, or not more than a glimpse, we got tremendous amount of insight into how Maximus oversees the Medicare Advantage plans last May 2022, when Maximus made public a redacted version of essentially all of their decisions with regard to Medicare Advantage. You can access this if you do a Google search for Chapter 13 of the Medicare Managed Care Manual. CMS now maintains that and related information on a web page, and on that web page you will find a link to the Maximus searchable online database of review decisions. So Maximus, for years now, has held Medicare Advantage plans to provide coverage for what fee-for-service Medicare would cover. It's as simple as that. cited in practically every decision, whether it's favorable or unfavorable, but the ruler that they use, the standard, the bar that they use is this 42 CFR 422.101, which basically says that they have to provide coverage by furnishing, arranging for, or making payment for, and I want to stress making payment for, all services that are covered by Part A and Part B of Medicare. That language has been in the Medicare Advantage regulations since 2000. When you go back and read the 4201P proposed rule, you'll see that they reference a Federal Register publication from June of 2000 when they're talking about, if the service can be provided in more than one manner, then the Medicare Advantage plan, can choose in which manner that service will be furnished. This comes from the same document, and some of the other things that we'll talk about as well. They're in that same document. The requirement to cover what fee-for-service Medicare Part A and Part B cover has been there for over 20 years. It's what Maximus has been using to adjudicate Medicare Advantage denials. It's what the OIG physician reviewers, even though, as Denise mentioned, that the OIG said that CMS wasn't entirely clear whether they could use internal criteria. When you look at the appendix of that April 22 report, you will see that the physician reviewer for the OIG disagreed with Medicare Advantage decisions on utilization review, including a couple of level of care cases, and disagreed because the Medicare Advantage plan appeared to use criteria that were not present in fee-for-service Medicare. So, one of the key points is that CMS is really just getting back to what really has been in place for a long time, even back to 2000. CMS is reiterating this. I just want to stress that what CMS is proposing is not new. It may not be what you're used to, it may not be what you experience, but I want to stress that it is not new. And the idea is that you cannot deny based on criteria that are not present in fee-for-service Medicare when it comes to basic benefits. Basic benefits are those benefits that are provided under Part A and Part B, as opposed to supplemental benefits, which are extra things that Medicare Advantage plans can offer that can improve health, things like dental services and gym memberships and other things. Those would be supplemental benefits. So when you're adjudicating a basic benefit, according to the proposed rule, you must use fee-for-service Medicare criteria in order to decide that. Next slide, Denise. This is I like doing this because very few of us were actually practicing in this field 23 years ago, back in 2000 when a lot of the rules for Medicare Advantage were set forth. But if you actually go back and read the rules and the discussions, you will find that what CMS envisioned is a very different world to what we have today. For instance, that same document that set forth most of the Medicare Advantage or regulations, and actually, it's still valid today, is that when a patient presents with an emergency medical condition, to an emergency department and then requires inpatient care, that until the treating physician says that the emergency medical condition is stabilized for transfer or discharge, the Medicare Advantage organizations are financially responsible for paying for that care without regard to prior authorization, without regard to the contractual relationship of the patient. That actually comes from the Social Security Act, 1852D. It's reproduced in the federal regulation 422.113B. It's tremendously powerful. And I want to make the point that financially responsible. So many times Medicare Advantage plans like to separate out the provision of a service from the responsibility to pay for the service. But when CMS addresses payers, especially when it comes to emergency services, unscheduled services, they actually address the financial responsibility of the MAO, not just the responsibility to make sure that the enrollee is able to receive the treatment for it. And that actually goes beyond Medicare into Medicaid and commercial plans as well. But it's important that the statutes and regulations do actually address the financial responsibility of the Medicare Advantage organization. So that's law and that's regulation, this first bullet. The second bullet, the services and referrals that a contracted plan provider gives are considered plan approved unless notice is provided that they won't be covered, and that the MAO cannot retroactively overturn the decisions by a contracted provider to provide the service or item. When you go back and read the 2000 creation of the Medicare Advantage rules, you will see that CMS envisioned the relationship between the Medicare Advantage organization and its contracted provider as a partnership, right? They were supposed to work together to provide services to the beneficiary. And this language about, if a contracted plan provider provides a service and it's considered plan approved and you can't retroactively overturn, that existed in the Medicare Managed Care Manual up until around 2015, when it was since replaced. It doesn't say the converse of this. What it says now, if you look now, is it basically says if a contracted provider is not sure whether a service would be approved by the MA or not, that the contracted provider should request a prior authorization. It actually is now silent on whether what to do with services that have already been rendered. But you can see that the idea that was in place was this partnership between the Medicare Advantage plan and its contracted providers, not to parse out whether you provided the service contracted provider, but we're going to deny you every turn that we get. That just wasn't how the plan was originally envisioned historically. Next slide, Denise. So to me, the most important part of this proposed rule is that CMS is clearly stated that inpatient hospital services is a basic benefit. And if you look at the Social Security Act, you look at the Medicare Benefit Policy Manual, Chapter 1, it's the first benefit that's listed in both the law as well as the manual guidance. Inpatient hospital services is a basic benefit. Now, we have all experienced, at least many contracted providers have experienced that, that CMS, typically doesn't interfere in issues between a contracted provider and a Medicare Advantage organization. And primarily it's on the basis of something called the non-interference clause, which is also part of the Social Security Act and is definitely a valid law, which says that CMS may not interfere in a particular price structure for payment. So, and that's a big distinction because CMS is saying that inpatient hospital services is a basic benefit. Basic benefits must be covered. But what CMS is not saying is how that inpatient care must be paid for. So if a Medicare Advantage plan chooses to negotiate with the provider and say, we're going to pay you a percentage of Medicare based on the MSDRG system, fine. We're going to pay you a percent of charges for your inpatients, fine. We're going to pay you a per diem for your inpatients, fine. CMS is not going to care about those things. CMS will never dictate a particular price structure for payment. But what CMS is saying very clearly in the proposed rule is that inpatient hospital services are a basic benefit. Next slide, Denise. So why is it important that we're calling this a basic benefit? Well, it's because there is a section in the federal regulations, 422 Part C, that has to do with beneficiary protections, and it lists the protections that are afforded to the beneficiary, including access to basic benefits. And one of the clauses that is present, that is required, that most providers probably don't bother to look at, but there's a section of the federal regulations that dictates what must be in the contract between the Medicare Advantage organization and CMS. And those sections of the regulations actually include that you have to grant you have to follow the provisions that are in the regulations of subpart C, which is beneficiary protections, as well as subpart M, which is the section on appeals and grievances and organization determinations. And so Medicare Advantage organizations are required to grant and follow the regulations that are afforded in subpart C, which is about beneficiary protections and benefits, basic benefits. So by defining and clarifying that inpatient hospital services is a basic benefit, it would require the Medicare Advantage plan, according to those regulations, to follow that. And so that is going to provide very important structure around Medicare Advantage and provider-based contracts, because at some level, you cannot have a Medicare Advantage and provider contract that violates sort of an upstream rule of engagement that the Medicare Advantage plan has with CMS. And so it's important that that providers ensure that these same interpretations and protections for patient benefits are not abridged in any contract that you may sign. The part that the CMS proposed rule does not necessarily solve is that the contracted provider is not afforded any appeal rights. The 5-level appeal process that I just described is afforded to Medicare Advantage enrollees. And it also extends to a non-contracted provider if the non-contracted provider agrees not to bill the beneficiary and therefore becomes what's called the assignee of the beneficiary. So, one set five-level appeal rights, but it does not include the contracted provider, and this proposed rule does not propose to change that at all. So as long as providers control the dispute process for a contracted provider, we said this on the previous PayerWatch webinar as well. I don't expect providers to see significant changes if your dispute avenues are the same as they were before, even with the clarifications and clarity being put forth by CMS. Next slide, Denise. So who's going to enforce these rules? And there are many options that are available to both members and providers. I can't necessarily be very prescriptive here because there's probably not going to be a one-size solution. But basically, the message that I'm putting forth to folks is that you need to consider all your available options. You need to have a vision. Like if you are one of the institutions where you stop after the peer-to-peer, or let's say you do the peer-to-peer and you stop after the written dispute process with the plan, if you stop there, you may never get to some of the levels that would recognize some of the things that CMS has put into this proposed rule. And so without getting too prescriptive, I'll just mention that providers have appeal rights usually granted by the plan. There are third-party resolution avenues that providers can also entertain, and some of this is going to be contract dependent, but there are things that providers can typically do, which with the ultimate one being some sort of legal action. And then members also have appeal rights for denials of coverage, for adverse organization determinations, and providers also very clearly have the right in the regulations to assist the members in appealing adverse organization determinations. And so, my point is that it's going to take a long-term strategy. You're going to need to have a vision of how you're going to attack these things, because what CMS did not do in this proposed rule is talk about enforcement of how these clarifications are going to be enforced. Next slide, Denise. The last, I think my last two slides, I'm going to talk about this this new proposed regulation, which is 422.138, prior authorization. So there is not an existing 422.138 in the Medicare regulations today, but in this new proposed 422.13 that addresses prior authorization, it is prefaced by MAOs have to follow Medicare laws, regulations, NCDs, and LCDs, and can't be more restrictive unless superseded by Medicare Advantage law. I think that's described in the preamble. But then when the criteria are not fully established, that Medicare Advantage organizations may create internal coverage criteria based on guidelines from medical specialty organizations or high quality literature, and they cite randomized controlled trials, prospective cohort studies with clear results, published in peer-reviewed journals, and large systematic reviews or meta-analyses. So what happens if neither one of these exists, where the NCDs and LCDs and other regulations aren't clear and there isn't this level of evidence? Well, what I would suggest is that it's going to probably fall to those same situations occur in fee-for-service today, and it falls to Medicare's reasonable and necessary standard, and arguing based on that standard for coverage. But by putting, I'm glad that CMS put a bar as to the quality of evidence, but there's no one perfect solution, because as we well know, there are some areas in medicine where that level of evidence doesn't exist. And so this isn't going to solve all the different situations, but I think it will be a significant help. Next slide, Denise. The last thing that I wanted to mention is, when CMS talks about, plans not being able to deny based on internal proprietary or external clinical criteria not found in traditional Medicare, CMS was very intentional, I believe, in their usage of cannot deny, because cannot deny is not necessarily the same as cannot use. because I believe that CMS will continue to allow the Medicare Advantage organizations to use criteria in order to approve, but not to deny. But then there are other, other sections will require transparency in terms of, publishing the UR policies and the creation of a UR committee. But as far as what the future will be for the UR screening criteria, I think we need look no further than what happens today with fee-for-service Medicare. So I know that many hospitals today, now even 10 years into the Two-Midnight Rule, still utilize screening criteria for Medicare fee-for-service patients. And in fact, CMS did allow, when the Two-Midnight Rule came out in 2013, did allow the continued use of screening criteria, not to determine whether a case was appropriate for Part A payment, but to help discern whether the patient needed to have continued hospital care or not. Recognizing that both observation and inpatient criteria represent hospital care, and that if you're not meeting either observation or inpatient criteria, if you don't meet either one, then the need for hospital care, may be questionable. So remember that even in the Two-Midnight Rule, you have the two-midnight expectation of necessary hospital care, and some hospitals still use these criteria to help discern whether any hospital care is needed. Now, that any hospital care does not equate to inpatient criteria. In the two major screening criteria that I'm aware of, if you meet the observation level, which is a lower bar than inpatient, then you meet their criteria for hospital care. Ultimately, though, it's the decision of a physician, but these tools, which are still used to some extent in fee-for-service today, can be used to approve, in my opinion, according to the proposed rule. They just cannot be used to deny the care. Only fee-for-service criteria can be used for that. And with that, I'll hand it back over to Denise.
Eddie,
Thank you.
Eddie, Brian, Kendall, just two questions. I wanted to bounce off all of you before we transitioned over to Bill. Given that we're almost 20 years into this, and a couple of us have been in practice since the beginning of this, I don't know, Brian, if you were around in 2000 when this started, but I'm dating myself. What's your opinion as to why CMS has deliberately chosen to stay out of or to shy away from the dispute resolution process yet again in this, and just to keep it internal, not it's almost like it's a third rail to CMS with this, and yet it's the source of essentially why we're back here again trying to clarify this is based on perceived abuses by payers from providers of this whole process over the last 2 decades.
Yeah, Kendall, I mean, that's a great question, and I wish I had an answer for that. I mean, I'm not aware of any statute or regulation that would prohibit CMS from granting appeal rights, except for the non-interference clause. And I think most of the hesitation that CMS has in getting involved into disagreements between contracted providers and Medicare Advantage plans, it typically boils down to payment, right? I mean, the services typically have long been provided, and boils down to whether something should be paid, and that, I guess, in CMS's previous interpretation, has gotten close to a particular price structure for payment. Now, I think that CMS is very very careful in this proposed rule to not address payment for services, at least how services should be paid. But again, to define that these are that inpatient hospital care, access to subacute rehab, access to inpatient rehab hospitals or facilities, they are basic benefits. I mean, CMS specifically called out those three, inpatient admissions, SNFs, and IRFs. That access to that is a basic benefit. And so, yeah, I mean, it's not an answer to your question, Kendall. It's a great question. But CMS, to my knowledge, doesn't have anything in there that addresses the rights of contracted providers, because they expect it to be in the contract between the Medicare Advantage plan and the provider.
Yeah, I mean, I guess my opinion would be, I think from my interactions in some of the listening sessions with CMS, and now seeing kind of the significant, I think, regulatory change in posture with what they're proposing here, is that I think it used to be perceived as mainly a payment issue, that should be handled in the realm of your contract. Because what I don't think they really understood, and now I think the provider community has come out and been able to bring it to the forefront, was how difficult or sometimes how convincing plans can be that keep patients and providers from pursuing appeals, and sometimes how burdensome and how hard it is to actually appeal a decision. I don't think they had full understanding for benefits, for instance, post-acute care. How if a patient calls, it's going to be an hour, hour and a half with a bunch of barriers. If you get cut off, there's no protection. It's really a burden to appeal some of these decisions. So I think they felt like their oversight was in place on the benefits side, which is not, you can't contract away provide a patient's benefits. So if they have the right to post-acute care, that's not a provider payer issue, that's a patient benefit issue. And so I think what they didn't fully understand, and I think the provider community has given enough examples of, physicians think that plans don't cover post-acute like they do for Medicare. And I think they realized that the 5-level appeal process that they thought should be easy to pursue actually has been much more challenging, and people are no longer pursuing it like they would for something like Medicare. And so I think what really got them interested now to change this is that the OIG pointed it out now in 2 successive studies that were very prominent. And then it aligned with, I think, the majority of providers' experience, which is, wow, they really are not covering what Medicare should from a benefit standpoint. And then from a payment standpoint, I do think that where this regulatory change, I believe, will have a benefit to providers. If you're not contracted, it should at least level set that you're going to be able to appeal your payment denials similarly like you would a Medicare denial, in that you can go through the 5-level appeals process. From a standpoint of if you're contracted, obviously CMS will not get involved with that. But what this will do is that if you pursue dispute resolution, issue-specific dispute resolution, which most contracts have a way to say, we don't agree with your final outcome on this, you batch cases, and then let's say you agree to go to independent review or an arbitrator or some other dispute resolution. What is clear now is your level set will not be the plan's interpretation of interqual. It will not be the plan's interpretation of Milliman, if they applied it, if they didn't apply it. What it will be is the inpatient benefit for Medicare. And this clearly and specifically states that the plan cannot deny the basic benefits of Medicare. And basic is exhaustive. It's not the vision benefit, it's not the dental benefit, it's the basic medical benefits of Medicare, that they cannot use these criteria. So your dispute resolution in your contracts, and I think this is where Eddie's right, we need to take this back to our contracting teams, because if you want to dispute, the level set now is very clear. It's the coverage criteria that exist in Medicare. It's what's in the regulations. It's what's in NCDs and LCDs. It is not what's in interqual, and it's not what's in Milliman. And so instead of then getting, say you get a third-party independent reviewer that you agree, you take an at-risk dispute resolution process to a independent review, they're not going to level set against whether or not they interpreted interqual quite correctly. What we should be using our contracts for is what's the basic Medicare coverage criteria. It's what's outlined in the regs, and so now we know if Medicare covers it and an MA plan doesn't, we should have an organized fashion as hospitals to be able to say we should escalate this and dispute it, because now it's no longer all the different plans' proprietary criteria and interpretations of that. It's really what is in the regs, which is what we're used to doing with traditional Medicare. So I think that's where I don't think Medicare fully understood the extent of benefit denials that were not reaching their oversight mechanisms of level 2 independent review.
No, and both Eddie and Brian, I think that one thing that really gives me pause when they're talking about criteria and developing internal standards, et cetera, is the complete paucity of medical literature looking at case-controlled, double-blind, randomized studies of treating an acute disease process in observation versus inpatient. I mean, all of this is filtered down and distilled into an MCG guideline or interqual guideline. But when you go back and look at the original studies, none of them actually talk about the place of service for those disease processes, and yet they're being used to determine, and will probably continue to be used to determine or support observation or inpatient. There was never the intent in any of those studies to do so.
And what's interesting is most of the coverage criteria for the plans from MA plans, they really list the Medicare definition of observation, 24, rarely 48 hours. And the intent of it is to determine if you need to be an inpatient. So it's hard to, so from our standpoint, logically, it's always been how can somebody be in observation for, 4 or 5 days for an MI? It doesn't make sense. But now if we are able to use that, like the 2 midnight rule, they're supposed to be advanced if they need hospital only level care for more than 2 midnights. And our provider believed that, and we feel that that's reasonable. It's a lot easier to dispute than saying they'd never met inpatient in interqual, which used to acknowledge the 2 midnight rule, and Milliman, which used to have, definition of observation was that, if you fail to meet safe discharge criteria, that you should be considered for observation, you should be considered for advancing for inpatient if you need continued observation services. Now it defers to the contract. I think this gives the level set. This gives us a level set that we at least needed if we want to exert our contract. But at the end of the day, if you're contracted, you're gonna have to look at your contract to be able to resolve the disputes, because we don't believe that all of a sudden all the MA plans are going to be like, oh, okay, we've been getting this wrong. We don't expect that to be the change.
Yeah, and Kendall, to your point, when CMS says that they're allowing plans to come out with, clinical criteria based on the evidentiary standard, that is only in areas where the CMS guidance is incomplete. And I don't believe that the CMS guidance is incomplete when it comes to what's appropriate for inpatient care, what's appropriate for skilled nursing facility, for inpatient rehab facilities. I don't believe that's incomplete. But you're absolutely right. That standard, that you couldn't do that type of study to determine, whether inpatient or observation is appropriate. That doesn't lend itself to a randomized controlled trial, to a prospective cohort study, to a meta-analysis, because it's honestly primarily a payment issue rather than a clinical issue. But yeah, I mean, the rules that Medicare has with regard to those 3 explicitly listed basic benefits, and CMS proposes to explicitly list those 3, I think, in the revised 42.101. It is an area where Medicare's guidance is not incomplete. I believe it actually is complete. That being said, the screening criteria that are out there, I'm not going to talk about individual criteria versus another criteria, but some of them are closer and can be used in a manner consistent with the 2 midnight rule than others. And I will just say that some of them, one of them has gotten a lot further away from the 2 midnight rule. The other one, when used properly, is actually a lot closer than I think than people would recognize. But the problem being, it's not often used in the manner intended.
The last question I might have for both of you is, do you see with the somewhat improved clarity through this proposed rule, an increase in the ability, or an increased power or influence in NCQA and in URAC in investigating plans and making determinations of whether they're playing fair as set forth under the intent or the literal interpretation of these rules going forward? It's been an underused third-party arbitrator of fairness in the past. Do you think that's going to change at all with this proposed rule?
Yeah, Kendall, I mean, I don't have any direct experience with that type of review activity, but to the extent that these organizations are reviewing payer activities to ensure that they're consistent with the regulations, and making that a part of their certifications, I think that the increased clarity will certainly help. Yeah, I think it will be helpful.
Okay.
All right, let's move on to, thanks everybody, lots of good questions and responses. Let's move on to see what Bill has to tell us about some of the legal regulatory aspects of this proposed rule. And also, if you have questions for the group, you can put them in the question box in your control panel, and we will do our best to get to your questions. We plan on going until 15 minutes after the hour. So if you can stay on for that long, we will try to get to your questions. So Bill, go ahead with your presentation.
I should unmute first. Thank you, Denise. So last time I was on, we dipped our toes into administrative law to talk about the difference in legal weight between guidances and rules. The difference being rules have the weight of law and guidances don't, and how that dealt with this proposed rule, essentially taking a lot of guidance language and elevating it to the position of rule. This time I wanted to dip our toes into two different topics of administrative law, two things that make it difficult or add complication to the idea of for parties that want to take any of these decisions to litigation. And while there is plenty of litigation under administrative law, these particular topics are extra qualifications that often need to be thought of before a party can take an administrative decision to litigation. So the first one of those I'm going to talk about is the exhaustion of administrative remedies. I'm sure you're familiar with the idea because payers have their own version of this internally. And this is the idea that if you want to seek redress from the courts for an administrative remedy, you have to exhaust all other remedies that administrative agency has. So any process they have to get to a final decision, you have to go the entire way, or you have to hit a real complete roadblock that the court will acknowledge as something that can stand in the place of a final decision. Once you've done that, then you are considered to have exhausted the administrative remedies and you can actually get into court. Or more likely, you can get into court and not have your case dismissed, which is what happens many times. One of the complicating issues with the exhaustion of administrative remedies is that while it exists generally as a judicial doctrine, it's also written into the statutes and regulations of some, but not all, administrative agencies, and the language is not always the same. So the specific application of this particular doctrine can vary by agency or topic depending on the specific language of the statutes or regulations of exhaustion that are included. So Denise, if you can go to the next slide. Okay, so for example, this is a partial of the very first sentence of this particular. So this is 42 USC 405G and this applies to CMS programs generally. Any individual after any final decision of the Commissioner for Social Security, that would now be the Secretary for Health and Human Services, made after a hearing to which he was a party, may obtain a review of such a decision by civil action. And this is part of a larger paragraph that includes more details of the procedure. But so this is the idea, basically, that if you want to get to a civil action, what you need to do is you need to have a final decision, and that it needs to have been after a hearing to which CMS was a party. So it has to be a hearing that they were actually involved in. So Denise, can you go to the next slide? So for Medicare Advantage, the particular, or one of the particular rules, but the most applicable of the rules we're looking at is 42 CFR 422-612, which allows you to seek judicial review of either an ALJ's decision or a Medicare Appeals Council decision. If it's an ALJ decision, you have to apply to see if the Medicare Appeals Council will review it, and they have to refuse to review it. And then it has to meet a minimum amount in controversy that's set every year by the Secretary. I believe this year that amount is $1,850, so $1,850. So it's not a terribly high threshold. But if it's below that, because of this rule, it's not even an option. If you did appeal to the Medicare Appeals Council and they did decide to review it, their decision has to be a final decision of CMS. So that means their decision has to actually conclude the issue. If their decision is to send it back down for further review, which might then come back up to them, that's not a final decision, and that you can't go to court with. And then in addition, it also has to meet the minimum threshold. So yes, Denise, can you advance it? So that deals with exhaustion. And I'll sum up both of these at the end. The other issue that we're going to look at is the issue of judicial deference to executive decisions. So let's say you do get into court and you're arguing about, with CMS or with the decision made by the ALJ or the Medicare Appeals Council. There is a doctrine of judicial deference to executive decisions that you're going to have to deal with. The standard has been in flux given the change in the Supreme Court and the makeup of the different factions in there over the past decade or so. So the standard for a long time, since 1984, has been known as the Chevron deference standard. And that said that courts have to accept the reasonable interpretation of an agency of any ambiguity in its statutes or regulations. So in court, when the agency is explaining its own reasoning of its own statutes and regulations, anything that's ambiguous, the court is supposed to accept any reasonable interpretation they have. But over the past about a decade, but more recently as the faction supporting this has grown, this deference has been, depending on who you talk to in the legal world, has been either replaced or narrowed, or this has been placed on top of Chevron deference, is what's called the major questions doctrine. And this says that the court doesn't have to defer to an agency when it's making interpretations when they are concerned with questions of vast economic or political significance. What does that mean? The Supreme Court will tell you when it thinks that it meets that standard. If you are really interested, I would look up the cases that involve the major questions doctrine and read through them. Though if you're not an attorney, you might want to also refer to someone who may have explained those cases in a more legally sophisticated manner. One thing to see from these, though, is that what they're concerned with is the interpretation of ambiguous language. No deference is ever given to a decision that you can show clearly contradicts unambiguous language. So, Denise, if you can advance it. So this is where we get to the important part. What does this mean to you? So if you're considering, if any party is considering whether or not to take a decision made by CMS or any administrative agency to the point of litigation, you need to consider these two things. Have you exhausted all of your administrative rights? Have you gone through every process and reached a true dead end? And if you have, then litigation would be genuinely available, which means you can not only sue, but your suit would survive a motion to dismiss. But then you also need to consider, is litigation viable? Is it a good idea? Because you have to consider what kind of deference is the court going to give to an agency's decision? And do you have a good argument that could remove deference from that decision? And I think importantly, what Eddie and Dr. Moore talked about with the new clarity of language is where this can help if you're getting into the position of litigation, because then you're in a better position to argue to a court, this is not ambiguous. This is clear language. They are contradicting that clear language, and there is no deference. There doesn't need to be any deference given to the wrong decision. The language is clear, it can't be contradicted. As always, though, if you are considering going to litigation, make sure you talk to an attorney, because these are, as I said, this is dipping our toe into these issues. These issues are quite deep and complex.
All right, thank you, Bill.
Thanks.
All right, I'm going to walk you through how to submit comments to CMS, and then we'll see if we have any questions. Again, if you have questions, please enter them in the questions box in your control panel, and we will go through those at the end. So here is the link, very lengthy link to get to the CMS comment page. Again, if you just want to go to search your favorite search engine, do CMS-4201-P. You will also pull it up, look for the result. It starts with www.federalregister.gov. That's the site you need to go to in order to submit your comments. You are filing a document into an official docket. Any personal information, including your comment, text, or uploaded attachments, may be publicly viewable on the web. So make sure you don't use any PHI. I think we say that about 5 times in the next few slides. This is what the page looks like. So this can help you understand if you are on the right page or not. It's going to say Federal Register at the top. And then it has a very lengthy title, and then down in the on the right-hand side, it will be in green, submit a formal comment, and that's where you click to submit your comments. Now, when I looked yesterday, there were like 136 comments submitted. CMS does review their comments before, as they come in, before they publish them. So even if it might say, there's 4,000 comments, you may be only able to read 3,500 of them. So they're not obligated to publish every comment. They may opt not to publish them if there's PHI or something to that effect in there. When I looked yesterday, it still said read the 3 public comments, but when I clicked on the 3 public comments hyperlink, it actually showed there's 136 comments. So not sure, the disconnect there usually does tell you the number that they have received as well as the number they have published. And anyway, that's what the site looks like. This already went over at the top of our talk today. This is provision E. These are the 4 areas that we talked about today as far as utilization management and prior authorization. And our template that you can download from this presentation gives you an area to address these 4 items. Now, you need to put in your own thoughts, your own suggestions, your own comments, your own stories. Okay, we don't have it, templated what your response should be. We just have areas in the template for you to put your own information in there. If you want to comment on additional things in the proposed rule like access to SNF benefits or rehab benefits, I believe American College of Physician Advisors also has a template, and I believe it includes those additional areas as well. And I think it's available. I don't know if Brian or Eddie, if you know, I think it's available to the public on their website. So make your voice heard. Consider writing your comments or voice transcribing your thoughts and concerns before attaching to the comment section. You can put in, you can type comments directly onto the web page, but you can also upload a document. Use your active voice. Think about words like unfair and unjust. How would you describe your experiences to a panel of CMS administrators in Congress if you were there in person? Citing examples, and I know Dr. Moore really emphasized this when we met on January 18th. Cite an example with specific patient encounter in mind. Again, no PHI though. And then, of course, we have a Word template for you.
Denise,
when you go ahead.
I'd just add to emphasize what Brian had spoken about 2 weeks ago. In reading through some of the submitted questions and examples that are current on the CMS website, probably some of the most powerful ones were physician advisors who had submitted just completely outlandish and egregious denials, 7-8 day stays in observation, denials for inpatient care where the patient had, just as an example, not sure that it was actually included, something like a hemorrhagic stroke, suddenly aphasic and seizing. I mean, just things that are just make you bang your head into the wall. They had redacted the PHI and then included that specific denial, and then gone on to comment that this was fairly typical of what their organization was experiencing. So those, when you have objective third-party evidence in hand to attach to it, become incredibly powerful and attention-getting. Brian, I think.
I agree.
No, I think the case examples, like I had a case where I was trying to get 3-discipline rehab for a stroke and the medical director would not approve it because it was not they only approved spinal cord injuries is what I was told. And it's a real story, and I submitted that as a grievance to CMS. I think that if we get our real stories in, and I wouldn't attack any one plan, because, honestly, I think we're all sometimes surprised that who's the difficult plan in our area might be the easy plan in another area that actually seems to follow Medicare Advantage, or Medicare coverage criteria. So just use your examples. And I would absolutely, like Kendall said, blind them, remove any information that's protected. I would personally remove any, organizational information, but I would demonstrate the types of denial letters that we see for care that in their own letter looks like it's obvious it should be covered by Medicare. And I think that really opens eyes. I wouldn't use the outlier example if it's not what your normal experience is, but I would use the example that doesn't require much reading to be able to say, wow, there's no way Medicare would approve of this.
Especially where they're contradicting themselves within the letter. Those are really just eye-opening. They said, we would have covered this if the patient had pulmonary edema, was hypotensive and hemodynamically unstable, and we note that the patient's chest x-ray had pulmonary edema, bilateral pleural effusions, they had a blood pressure of 60, where they described the objective criteria in the same letter. Those you wonder, but it does provide clarity that we're not whining. This is, in fact, this is the reality in the universe that we work and try to function in.
All right, so when you get to your comment submission, there is an area where you can type in comments, but then you can also add your file as well. I think what we did when we responded to the RFI is just put a little introductory paragraph in the comment section, and then we attached the file that had our full comment on there. We will be posting as well. We will be submitting our comments on behalf of the association prior to February 13th, and we will share that on our website if you're interested in reading what we had to say from the association. And then as far as the email, your email will not be posted on regulations.gov, but I would recommend to click the opt-in to receive the email confirmation of submission and your tracking number. That way, because, when there's 4,000 comments on there, if you want to go back and read your comment or point somebody to your comment, you'll have the tracking number available to you so you can find it quickly without having to search through all of those. So they're not going to post your email on their site, but I think it's worthwhile to at least know that, yes, they did receive your comment and you have a tracking number for it. They do in this where it says, there's one that says, what is your comment about? I think it's funny how they have worded that, because your options are these drop-down selections of, are you a physician or nurse at the hospital? That's not really what your comment is about. That's kind of like who you are. So I think that was a weirdly worded thing. But anyway, you have choices from the selected drop-downs. Consider adding an example, as we just talked about, of an egregious denial, identify any patient information, and we think your comments may carry more weight if you can give some specific examples. Attachment requirements, they will take up to 10 MB, and you can use any of these file types to submit. What I talked about, I would recommend that you opt in to receive email confirmation that they did get your comment. So create and submit your comments to CMS by February 13th. Use your active voice, use real scenarios, and you can download a template from this webinar, or you can email me if you're having trouble getting it downloaded, denise@adam.org for the template. So let's see, if you have questions that we don't get to or things you think of afterwards, you can certainly email any of us on this list, and we will do our best to try to get you an answer. But let's see what questions we have right now that we might be able to answer while we're still all together. So Alexander asks, so MAO can no longer, so can an MAO no longer say to a UN team member, this patient does not meet for inpatient based on MCG criteria?
Theoretically. I think practically, just remember that, peer-to-peer conversations are not a formal denial. They'll have to issue a denial letter. So, we are hoping this clarification is enough that the 2 midnight rule is what they would have to quote. And so if you get denial letters that are benefit denial letters that are quoting interqual or other criteria that are not contained in original Medicare language, I would consider forwarding them, to the plan's compliance team, and potentially finding a way through your organization to see if you can escalate them to CMS or de-identify them to see if it's okay. Again, that's another area that if you use a Medicare Part C and D appeals mailbox and you de-identify things, you can actually ask them a specific question. Is it okay? This is the letter we received. Is it okay for them to do it? And you'll get pretty clear answers back often.
Another question from Lisa. Another big chunk of this denial puzzle is the egregious stripping of valid diagnoses to accomplish DRG revisions favorable to the MA plan. Does any part of the proposed rule help hospitals fight those types of denials? Clinical validation denials are adverse determinations being used on internal plan interpretations rather than valid clinical evidence of a high level. So this rule does not address clinical validation at all, from my understanding and from what I saw.
Yeah, I mean, I'll add on to that comment. I agree, Denise. I mean, coding rules and clinical validation, I mean, we are bound to follow them. Like all the parties are bound to follow them. And this rule, it doesn't change that. But what Lisa said is exactly correct, is that a denial based on a clinical validation, based on stripping a diagnosis from a claim, that's an organization determination. That's an adverse organization determination that's changing the level of payment that is due for that claim. And that is subject to all the different appeal pathways that would otherwise be available for organization determinations. Now, contract providers, again, do not have on their own behalf the ability to access the CMS 5-step appeal process. Non-contracted providers with a waiver of liability would be able to fight those types of clinical validation denials using the 5-step appeal process. A contracted provider, if not representing a beneficiary, is going to have to follow the process outlined in your contract. And as Bill Haynes so eloquently described, you have to exhaust that before you can go further through that pathway.
Exactly. Read your contracts if you have them.
Okay, so Christine asked, for clarification, will this require MA plans to follow the 2 midnight rule, or will it still be based on your contract language?
So
I
2
guess
weeks
you could
ago,
contract away the 2 midnight rule.
Kendall, Kendall shared a reference back from 2014, and Bill talked about it as well, that back in 2014, CMS was saying that that Medicare Advantage plans, had to provide all the services of Part A and Part B, but they could approve for inpatient a stay shorter than what fee-for-service Medicare would approve, and that guidance is 10 years old. So I mean, there is guidance, and I apologize for the phone call, but from spam risk. I mean, there is definitely solid guidance out there, and examples, multiple examples from Maximus and OIG reports that we talked about. There are things out there that show that Medicare Advantage plans are actually bound by rules, and the question is, how do you get that to stick? And I think that's what Bill was trying to get at with his conversations, is that getting it to stick, like understanding what the rules are isn't necessarily hard to do, but what you do with that information and what avenues you choose to take it is going to require a careful discussion in each organization and decisions made based on that.
And if I could add on to that, Bill put it well in the last webinar, that anything other than yes from CMS means it's left open somewhat to interpretation, trying to go figure out the regulatory construct behind the 2 midnight rule applies or not. I would suggest that every provider on this that wants it to apply or wants it to be clear, puts it in the comments that say, please make it clear if the 2 midnight rule is the governing inpatient outpatient determination factor, because we like it for our hospital. We feel like it's reduced friction, whatever it's going to be, we feel like it's reasonable, whatever you think. But if you want the 2 midnight rule to apply to Medicare Advantage and make it clear that that's Medicare coverage criteria, I would just ask for the simple yes, no, so that we are not stuck in this gray area of having to kind of construct legal connections about why it is actually the governing rule for traditional Medicare.
Yeah, and if they decide not to be as clear as we would like them to be, do what the payers do. Take the position that that you think is correct, and then fight for it. Whatever options you have, whether it's through your contract or through the non-contracted statutory system available that Eddie talked about. If there is this ambiguity, take a side. Take your side and then argue for it every time you can. Otherwise, you're leaving it in the hands of the payers to decide what that means.
I mean, I do think that CMS, in their proposed rule, in what 422.101, is proposed to say, talking about needing to cover basic benefits and specifically calling out the 3 examples of inpatient admissions, nursing facility rehab, and inpatient rehab facilities, and citing the regulations that contain the criteria, of coverage. It is as clear as CMS has gotten. CMS has given examples of following Medicare fee-for-service criteria. They go on to say inpatient admissions, as described in 42 CFR 412.3. 412.3 is exactly where the provisions of the 2 midnight rule and the inpatient only list, the so-called case-by-case exception live. CMS is directly pointing to it. Is it as clear as a yes? Well, no, it's not as clear as a yes, but it's a lot clearer than I think, what CMS has said before.
That's definitely true.
All right, guys, we're coming up on the end of our time here. You guys had some good questions we didn't get to. We'll do our best to put the questions together with the questions from the last webinar and get something out to you to help you with your questions about this particular topic. So I want to thank Dr. Eddie Hugh and Dr. Brian Moore for meeting with us today. They really have given us some great insight as to what this proposed rule means and great suggestions on how to comment back to CMS on this proposed rule. And thank you, Bill and Kendall Smith, for being here as well and giving us a little more color commentary and regulatory insight as to what's going on. So thanks, everyone, and make sure you get your comments in by February 13th. If you have any questions, please let us know. Thanks. Have a great day.
It makes a great Valentine's present. Stick it in a card to your loved one.
Exactly.
Happy
Thanks,
Valentine's Day.
Bye.